So, Liran, to me as a practitioner, not as an attorney, I can't give legal advice, but as a businessman, I would say almost any person who owns a property in California should have an estate plan. Maybe it's a living trust or something else, but it should have something that anticipates that they may be incapacitated or, God forbid, pass. Fair answer. Rather than buying it in your own name, you should have something of a different strategy than that.
No, that's the perfect way to look at it. Is if you own any piece of real property, most likely your gross value here in California is over the minimum amount. And since you're over the minimum amount, you need something called the living trust or revocable trust in order to avoid the courts when you pass away or when you are incapacitated. There are proceedings, obviously probate and conservatorship proceedings that are done to move title from one person to the next, right? That's the whole point of probate, is to move title from you, who has just passed away, to your children or to whoever it is, through the process called probate. And at the end of the day, title is perfected in those people's names. Yeah. So we try to avoid that process by doing it with a trust. And once you do the trust, you don't have to go through the courts at all.
By far, and again, I'm not an attorney, so I have to be careful never to give people legal advice, but I'm allowed to give my personal experience and business insights. To me, by far the biggest misconception is, oh, I don't have to worry about a living trust or estate plan. I have a will, so I'm good. So go ahead. How would you answer that if you weren't giving me legal advice, but you and I just talking in a bar after a couple of beers and we're friends? What would you say about that? Like, how wrong is that answer?
Oh, it's very wrong. So a will is what I like to call a ticket to probate. It's an admit one to going to court. With a will, you are basically giving instructions to the judge of what you want to be done with your assets. Now, those instructions, if you literally take them and put them into a trust, it does completely different things, right? It tells the judge, I don't want you to handle any of this. I'm going to do this privately in an office with an attorney or with my loved ones, and we're going to figure this all out. So it's not in public records, one, right? You could figure out what Michael Jackson owned, let's just say, right? It's not hard, it's in the public records. So you get that out of the way. And then the fees of probate is the other major thing that everybody wants to avoid, right? On a $1 million house, it could cost you almost $46,000 for the fees to the attorney plus the fees to the person in charge or the executor. And that's minimum, right? So if there's more like sales of houses or some litigation involved in there, that's just raise that up and double, of $46,000 easily. So you want to avoid those fees by spending a couple extra dollars right now, getting yourself into a trust, making sure all your choices are done properly, and you effectively avoid all that hassle.